Elliot Graves was 41 years old when his wife stood in the lobby of First National Bank on a Tuesday morning in October, flanked by her attorney and a county sheriff's deputy, holding a court order that gave her the legal right to open the safe deposit box she was certain contained $500,000 she believed he had hidden from her. He had spent 13 years being the kind of husband who kept nothing from anyone. A man who left his phone on the kitchen counter face up because there was nothing on it worth hiding, who discussed every significant financial decision with her before making it, even the ones that were technically his to make alone, because that was what partnership meant to him, and he had never once questioned whether she felt the same. He had taken a second job for 19 months in the early years of their marriage so they could pay off her student loans before the interest compounded further, and he had done it without framing it as sacrifice, because to him it was not sacrifice. It was just math, and she was the variable that made the math worth doing. She had no idea the box contained nothing she had imagined. She had no idea what it actually contained would dismantle every argument her attorney had spent 6 months constructing. And she had no idea that the moment she stood in that bank lobby with a court order and a deputy, and the full certainty of a woman who believes she has already won, she had handed Elliot Graves exactly the ending he had been waiting for. What she found inside that box would cost Vivienne Graves everything she thought she was about to take. And what she understood in the weeks that followed, alone in the apartment she had moved into 6 months earlier with such confidence, was the specific weight of a mistake you cannot undo. Before we jump into the story, comment where in the world you are watching from, and subscribe, because tomorrow's story is one you need to hear. The alarm went off at 5:30 a.m. and Elliot Graves was already awake. He had been awake since 4:50, lying still in the guest room of the house he had lived in for 9 years, listening to the particular silence of a home where someone is sleeping in a different room, and the space between you has stopped being accidental. He had moved to the guest room 3 months ago. Not because anyone had asked him to, because the alternative was lying in the same bed as a woman who had already decided something and was simply managing the calendar of it, and that particular geography had started to feel dishonest in a way he was not willing to maintain. He got up without the alarm. He showered in the guest bathroom and dressed in the dark, gray slacks, a white button-down, the kind of clothes he wore to client meetings, and went downstairs to make coffee. The house was a 4-bedroom colonial in a suburb 20 minutes east of the city. A neighborhood of mature trees and good schools and streets where people walked dogs in the evenings and knew each other's first names. They had bought it 9 years ago, 2 years into their marriage, in the specific optimism of a couple who believed the space they were making for themselves had no ceiling. Elliot had done the inspection himself, walking the foundation with the inspector and asking the questions that needed to be asked, checking the attic framing and the drainage grade and the age of the mechanicals. He had spotted a hairline crack in the east foundation wall that the inspector had noted as cosmetic, and Elliot had assessed as the beginning of something that would need attention in 5 years. He was right. He had repaired it himself in year 4 with an epoxy injection system he researched and installed over a weekend. The kind of repair that is correct and complete and invisible from the outside. The kind that no one notices because it works. He made coffee in the kitchen he had renovated 2 summers ago. Subway tile he had set himself. Cabinet hardware he had replaced on a Saturday. Pendant lights over the island that he and his brother had hung on a Sunday in July while Vivienne was at her mother's. The kitchen was the best room in the house. It was warm and well lit, and every surface in it was the result of a decision he had made with care. He stood at the window with his coffee and looked at the backyard in the early gray light. The flagstone patio he had laid over 2 weekends, the summer before last. The flower beds his mother had helped him plant along the back fence. The garden shed in the corner, where he kept his tools organized in the specific way of a man who considers the time it takes to find a tool to be a tax on getting things done. Elliot Graves was a CPA. Had been for 16 years. He had his own firm. Small, deliberate. 3 associates and a part-time administrator that handled tax strategy and financial planning for a client base of small business owners, a few high net worth individuals, and 2 family trusts that had been with the firm since before he had bought it from the man who founded it. The practice was not glamorous. It was not the kind of work that people mentioned at dinner parties with excitement. It was the kind of work that required precision and patience, and the particular gift of being able to see a financial structure from multiple angles simultaneously and identify the thing that was wrong before it became expensive. Elliot was very good at it. His clients stayed with him for a decade, then 2 decades, then sent their children. He drove a 2015 Volvo S60 in dark blue, a car he had bought used with 40,000 miles on it, because it was safe and practical, and he did not care about cars in the way that some men do. It had 114,000 miles on it now and needed new rear brake pads, which he had been meaning to handle for 6 weeks, but had not yet scheduled because there were things that had been occupying his attention that he considered more pressing. He kept the interior clean, no food, no clutter, a phone holder mounted on the dash, a spare umbrella in the back seat, because a clean car cost nothing, and an untidy one cost time in small, continuous ways. He poured his coffee into a travel mug, navy blue, simple. The one his assistant Karen had given him for his 40th birthday, with the firm's initials printed on the side in small gold letters, and he stood at the kitchen island for a moment, drinking it, in the quiet of a house that was still and would soon be only technically his. He had 2 client calls that morning, the first at 8 and the second at 10. He took them from the kitchen island with his laptop open and his coffee going lukewarm beside it, talking through quarterly estimates with a restaurant owner in the first call and a business succession timeline with a second-generation family manufacturer in the second. 2 conversations that were each the specific kind of technical and human simultaneously. Here is the number. Here is what the number means. Here is the decision in front of you. Here is what I would do and why. He was good at this. He had been good at it since before it was his own firm. When he had worked for someone else's firm and clients had started asking to be transferred to the younger guy when problems came up, because the younger guy looked at the problem longer and from more angles before he said anything. He had bought the firm 8 years ago from a man named Gerald Moss, who had built it over 30 years and was ready to stop. Gerald had 2 associates and a client base of 41 small businesses, and 4 high net worth individuals and 2 family trusts. And he sold it to Elliot for a number that Elliot had borrowed from his mother and repaid in full in 4 years. He had kept Gerald's associates, hired 1 more, restructured the service offerings, and lost 6 clients in the first year who had wanted Gerald specifically and were not interested in a substitute. He had gained 11 in the second year and 23 over the following 5, and had not had a client leave in 3 years now, which was the number he was proudest of, and which he mentioned to no one because he was not in the habit of talking about his own numbers. They had met at a professional conference in the city 14 years ago. She was in corporate law then, 2 years into a position at a mid-size firm, working the kind of hours that mean you attend professional conferences on Saturdays, not for networking, but because Saturday is simply another workday, and the conference is where the work is. He had been in a breakout session on business succession planning, and she had sat 2 rows ahead of him and asked the presenter a question that was sharper than the session warranted. The kind of question that signals a person is thinking at a different resolution than the people around them. He had introduced himself afterward. She had been direct and slightly impatient, which he found clarifying rather than off-putting. He had asked for her card. He had waited 11 days before calling, not as a tactic, but because he had wanted to be sure he was calling because he meant to, and not because the energy of the first meeting was doing the work. They had been married after 2 years of dating. He had proposed at home, in the kitchen of his apartment then, on a Sunday morning over coffee. Not because he lacked imagination, but because he believed that important things should happen in ordinary settings, so that ordinary settings carry weight forever afterward. She had said yes and cried and laughed at herself for crying and kissed him 3 times. He thought about this now, standing in the kitchen he had renovated for them. And then he put it away because there were client files to review before the morning. The first sign had been a change in how she talked about money. Not a dramatic change. Vivienne was too precise for drama. More like a calibration, a subtle shift in reference points. She had been a partner at her firm for 4 years, which was a significant income. A number Elliot knew exactly because they filed joint returns and he prepared them. In the 3rd year of her partnership, she had started mentioning, in the particular offhand way that means something has been thought about in advance, that she felt their financial arrangements were not fully equitable, that she contributed significantly, and that the visibility of that contribution in their shared accounts was not proportional to its size. He had listened carefully and asked questions, and they had restructured their accounts so that she had a separate account for her discretionary spending, which was what she had asked for, and he had thought the matter was resolved, because the matter had been addressed. It had not been resolved. What he understood later was that the conversation about accounts had not been about accounts. It had been a reconnaissance, a first assessment of how he responded, how much he pushed back, how much he knew about what she was thinking. He was a CPA. He should have recognized reconnaissance. In retrospect, he thought he probably had, and that the part of him that loved her had chosen to interpret it as something simpler. The second sign was a lawyer she mentioned in passing, a family law attorney named Donna Peel, whom Vivienne described as a friend of a friend who had done brilliant work in a mutual acquaintance's complicated divorce. She mentioned it once, at dinner, and then did not mention it again. Elliot filed the name without comment. He knew the name. Donna Peel was not a friend of a friend type of attorney. She was the kind of attorney you researched before you retained her, the kind whose profile on her firm's website used words like aggressive and results-driven, and whose case record was specifically strong in cases involving contested assets. He had not been alarmed. He had been informed. The third sign was the question about the safe deposit box. They had maintained the box at First National Bank for 6 years. Elliot's firm kept one as a matter of professional practice. For original documents, client records that required physical secure storage, things that needed to exist in exactly one place and be retrievable with certainty. Vivienne knew about the box in the abstract. She had never asked about its contents. In the 7th year of their marriage, at a moment that appeared casual, but which Elliot recognized in the same way he recognized the reconnaissance about accounts, she had asked what was in it. He had told her, original articles of organization for 2 client entities, a copy of his firm's founding documents, original trust instrument copies for the 2 family trust clients, and a personal insurance policy document he preferred to keep in physical secure storage. She had nodded and appeared satisfied, and asked nothing further. 3 months later, she moved into an apartment in the city and retained Donna Peel. The divorce filing came on a Tuesday. He had known it was coming. Carol Hendricks, the attorney he had retained 4 months before Vivienne made any visible move, had prepared him for the timeline. He was at his desk reviewing a quarterly tax report for a client in the manufacturing sector when Karen brought in the envelope and set it on his desk with the quiet efficiency of a woman who had worked for him for 7 years and understood which deliveries required a different tone. He read the filing carefully. He read it the way he read any financial document, not for the conclusion it was trying to reach, but for the methodology underneath the conclusion, the assumptions embedded in the structure, the places where the numbers did and didn't match. It was thorough. As expected, Donna Peel's work was always thorough, built on the particular confidence of an attorney who had reviewed Robert Finch's 34-page analysis and believed she was holding something airtight. The list of contested assets was specific and well-researched, which meant Vivienne had been thinking about this for longer than 3 months, possibly significantly longer. The precision of certain items on the list suggested access to information she would only have sought deliberately, well in advance of any visible indication that she was preparing to leave. The firm was listed. The house was listed. The joint accounts were listed. The retirement accounts were listed. And at the bottom of the asset list, in the particular language of a filing that is trying to account for something it cannot fully name, was a line about contents of a safe deposit box at First National Bank, account held jointly in the names of Elliot James Graves and Vivienne Ruth Graves, believed to contain significant financial instruments and/or assets not yet disclosed. Significant financial instruments. He read the line twice. He understood immediately what had happened. Vivienne had assembled the picture of his financial life from the information she had: the joint returns, the visible accounts, the general professional profile of a CPA with his own firm, and had concluded that the gap between what she could see and what she believed he must have accumulated had to live somewhere. The safe deposit box was the only somewhere that was also inaccessible. She had made a structural assumption, the way people who understand some of a financial picture but not all of it make structural assumptions, and the assumption had become the centerpiece of her attorney's strategy. He set the filing down. He picked up his phone and called Carol Hendricks. "I have it," he said. "I know," she said. "I received a copy this morning. How are you?" "Fine," he said. "They've listed the box. I saw that." A pause. "Tell me what's in it." He told her. Same thing he had told Vivienne 2 years ago. Original articles of organization, firm founding documents, trust instrument copies, 1 personal insurance policy. He described each item. Carol was quiet for a moment. "That's everything?" she said. "That's everything," he said. Another pause. He could hear the particular quality of her thinking. She was an attorney who paused when she was doing something specific in her mind, and he had learned to let her finish doing it. "They're going to push for access," she said. "Probably a court order. They believe there's something in there that changes the picture." "I know they do," he said. "And when they get in there, and it's what you say it is, their entire asset concealment theory collapses." "I know that too," he said. "Elliot," she paused. "You're not worried?" "No," he said. "Why not?" He picked up his pen and looked at the quarterly report still open on his desk. "Because I'm a CPA," he said. "I know exactly what's in that box because I put it there. I know exactly what the firm is worth because I built it. I know exactly what's in every account because I manage them. There's no gap. There's just a theory about a gap, and when the box is empty of what they think is in it, the theory goes with it." Carol was quiet for a moment. "Then, okay, let them file for the order. We won't contest it." "No," he said, "we won't." He hung up and went back to the quarterly report. He would finish it before noon. He had a client call at 2. He had a dinner at 6 with his brother and his brother's wife, which he was looking forward to because they did not talk about the divorce, and his brother was funny in the specific dry way of a man who has lived long enough to find most things darkly amusing. He had things to do. and he would do them in sequence. He was, as he had always been, exactly himself. Carol Hendricks practiced family law from a corner office on the 16th floor of a building downtown, the kind of office that communicated, without making a production of it, that the person who occupied it had been doing this a long time and had won more than they had lost. She had been practicing for 28 years and had a particular reputation in cases involving financial professionals, accountants, attorneys, financial advisors, because she understood the difference between what a financial document showed and what a financial document meant, and she had found, over 28 years, that this distinction was where most of these cases were decided. She had listened to Elliot for 40 minutes on a Thursday afternoon in April, 4 months before Vivienne filed anything, and had asked 3 specific questions. What does the firm actually generate? Net of the salary you report on joint returns. Are there assets that are legitimately yours that your wife does not know the full scope of? And is there anything in your financial life that would appear, to a forensic accountant working only from disclosed records, to suggest concealment even if nothing is actually concealed? He answered all 3 in sequence. She made notes. She asked 2 follow-up questions, and he answered those too. Then she set down her pen and said, "Your wife doesn't know what your firm is actually worth. She knows I have a firm. She knows what I draw as a salary. She has a general sense of my professional standing. But not the retained earnings, not the client book value, not the asset position of the practice entity. No," he said. "We stopped having those conversations about 3 years ago. I stopped initiating them, because she stopped engaging with them, and I did not think it was my place to force a conversation she was choosing not to have." Carol looked at him for a moment. "Did you conceal any of it?" "No," he said. "The firm's existence is on every joint return we filed. The salary is on the returns. The entity is disclosed. The retained earnings are retained in the entity rather than drawn down, because that is standard practice management and not concealment. But she doesn't know the number. She never asked the number," he said. "There's a difference." Carol Hendricks looked at him for one more moment. Then she said, "All right. Here is what we're going to do, and here is what we are not going to do, which is equally important." What they were going to do was document everything. Patricia Lane, a forensic accountant Carol used on financial cases with the specific confidence of someone who had worked with the same professional a long time and knew exactly what they would produce, was brought in to prepare a complete and accurate valuation of Graves Financial Group, one that would be thorough, defensible, and based entirely on what the firm actually was, rather than what someone unfamiliar with small professional practices might assume it to be. Every client contract, every retained earnings statement, every asset, every liability, documented in sequence and reviewed for accuracy by Elliot himself before anything was filed. What they were not going to do was volunteer this information to the other side before required. Not because anything was hidden, because the timing of information in a legal proceeding is itself information, and because Carol Hendricks had 28 years of experience with what happened when the other side built a strategy on a wrong assumption and then discovered that the assumption was wrong in a setting of their own choosing. "The safe deposit box," Carol had said in that first meeting. "They'll go for it." "I know," Elliot said. "When they do, let them." The motion for access to the safe deposit box was filed 3 weeks after the divorce petition. Don Appeal's filing argued, with specific legal language that Elliot read once and set aside, that there was reasonable cause to believe the box contained assets material to the division of the marital estate, that the box was jointly held but effectively controlled by one party, and that access was necessary to ensure full disclosure. She attached a financial analysis prepared by a forensic accountant named Robert Finch, a man whose report on Elliot's known financial position ran to 34 pages and concluded, in measured professional language, that the assets visible in the marital estate appeared inconsistent with the income trajectory of a financial professional of Elliot's experience and tenure, and that therefore it was reasonable to infer the existence of assets not yet disclosed. The inference was wrong, not because Elliot had hidden anything, but because Robert Finch had made the structural error of estimating the lifestyle of a man who drove a 2015 Volvo with 114,000 miles on it and renovated his own kitchen by hand and did not own a boat or a second property or any of the other visible anchors that people use to estimate the financial position of someone they cannot see fully. He had assessed Elliot's income and concluded the gap between income and observed lifestyle implied concealment. What he had actually found was the gap between income and ostentation in a man who did not bother with ostentation because he had never needed anyone to know what he had. Carol Hendricks filed a one-page response to the motion for access. It said, in summary, the respondent does not oppose the court's granting of access to the safe deposit box and invites the court and the petitioner's counsel to examine its contents at their convenience. Donna Peel read this response, and from what Carol later described, was briefly uncertain what to do with it. Opposing counsel who do not oppose your motion in a case built on asset concealment are either very confident or very foolish, and Robert Finch's 34-page report had established enough professional certainty that foolish seemed unlikely. She filed for the order. It was granted on a Monday. The bank visit was scheduled for the following Tuesday at 10 a.m. Elliot knew the date. He was not there. There was no legal reason for him to be present, and Carol had advised him, with a particular measured emphasis of someone giving advice they expect to be followed, that his absence from the bank lobby would be both procedurally correct and strategically clean. He had a client meeting Tuesday morning. He went to it. At 10:07 a.m. on a Tuesday in October, Vivienne Graves stood in the lobby of First National Bank with Donna Peel and a county sheriff's deputy, and presented the court order to the branch manager, a man named Curtis Webb, who had worked at this branch for 11 years, and who handled the situation with the professional composure of someone who has seen unusual things and decided long ago not to have visible opinions about them. He led them to the vault. He retrieved the box, number 114, the long, narrow kind, a gray metal rectangle the length of his forearm, and set it on the table in the private viewing room and stepped back. Vivienne opened it. She stood very still for a moment. Donna Peel stood beside her and looked at the contents of the box, and then looked at Vivienne, the deputy, who had no investment in the outcome and was simply there to ensure the order was properly executed, looked at the ceiling. Inside the box, in precise order, were the following items: a manila folder labeled Client Entities, originals containing 3 sets of original articles of organization for 3 separate LLCs, none of which were in Elliot's name. A second manila folder labeled Graves Financial Group, founding documents containing the original purchase agreement for the firm, dated 16 years earlier, and the original articles of organization for the entity, also 16 years old. A third folder labeled Trust Documents, masters containing original trust instruments for 2 family trusts, both naming parties who were not Elliot Graves, a standard white envelope labeled Policy, personal containing a life insurance policy document, with a face value that was significant but structured in a way that made it non-liquid and non-marital under the applicable state statute, and a single index card placed on top of everything in Elliot's handwriting that read, "These are the contents of this box. There is nothing else." Vivienne looked at the index card for a long moment. Donna Peel was already doing the legal math, the math of a strategy that has just had its primary load-bearing column removed and is now being reassessed for what, if anything, remains standing. "Is this everything?" Vivienne said. She was not asking the deputy. She was not asking Donna Peel. She was asking the room, or possibly herself, in the specific voice of a person who has arrived at a destination and found it is not the place they were traveling toward. Curtis Webb, from the doorway, said, "That's the full contents of Box 1 Barg 14, ma'am." She closed the box. She stood there for a moment, with her hands flat on the table. Then she picked up her bag and walked out of the viewing room. Donna Peel followed her. The deputy followed Donna Peel. Curtis Webb, who had seen unusual things for 11 years and decided long ago not to have visible opinions about them, put Box 114 back where it belonged. Carol Hendricks called Elliot at 10:34 a.m. He was between meetings, standing in the small kitchen off the conference room in his office, pouring coffee from the office pot, the kind that was fine, but not as good as the coffee he made at home. "How'd it go?" he said. "Exactly as expected," Carol said. "The box contained what you said it contained." "I know," he said. "Donna Peel is going to need to recalibrate the entire strategy. The asset concealment framework is gone. They'll need to build a new approach from what actually exists, which is the marital estate as documented," Elliot said. Correct, he poured the coffee and looked out the small window at the parking lot below. A red maple at the edge of the lot had turned completely. Brilliant red, the kind of color that lasts about a week in October before the leaves fall. He had been watching it change over the past 10 days. "What's her position now?" he said. "She doesn't have one yet," Carol said. "She'll need a few days to regroup. I expect we'll hear from Donna Peel by Thursday or Friday." "And the firm valuation?" "Robert Finch's report is built entirely on the inference that something was hidden. Without that inference, his methodology is circular. We have our own valuation from Patricia Lane. Her report is thorough, current, and accurate." "Good," he said. "Elliot, yeah, you understood that the box was going to do exactly this," Carol said. It was not quite a question. "The box contained what it contained," he said. "I didn't engineer it. I just didn't move anything into it that wasn't already there." Carol was quiet for a moment. You knew that once she found nothing, the premise of their entire case fell apart. "I knew that if she believed something was there and went to the effort of getting a court order to prove it, and then found nothing, she would have demonstrated to the court that her legal theory was built on an assumption rather than evidence." He paused, which is what happened. A short silence. Then Carol said, "You're a very careful man." "I'm a CPA," he said. "Careful is the job." He finished his coffee and went back to his desk. Donna Peel called Carol Hendricks the following morning. Carol described the conversation to Elliot in a brief call that afternoon. Measured, professional. Two attorneys who had been across from each other before, and would be again, discussing a recalibration in terms that acknowledged nothing personal about the matter. Donna Peel did not concede the case. She did not concede anything. She simply noted that the evidentiary basis for the asset concealment argument was no longer present, and that her client would require time to assess the new landscape before further settlement discussions. Vivienne, by all accounts, spent 3 days not answering calls that were not from Donna Peel. She had told her mother and her closest friend that the divorce was going to resolve quickly and substantially in her favor, with a confidence that had been specific enough that both of them had clearly repeated pieces of it back to her in the days that followed the bank visit. Because Donna Peel's notes from their meetings in that period reflected a client managing the particular kind of social embarrassment that comes from having announced a victory that has not yet happened. She had been certain. The certainty had been architectural. It had structured her expectations, her timeline, her conversations with the people in her life. And the box had contained an index card and 4 manila folders and a life insurance policy. And the certainty had no longer had anywhere to stand. The case took another 14 weeks to resolve. Without the asset concealment framework, Donna Peel rebuilt her approach around equitable distribution of the documented marital estate. The house, the joint accounts, Elliott's firm valued according to standard methodology, the retirement accounts. Patricia Lane's valuation of the firm was thorough and defensible, and produced a number that was materially lower than Robert Finch's speculative estimate, because it was based on what the firm actually was: a small, profitable, relationship-dependent practice, with a client base that was, by the nature of the work, not transferable at will, rather than on what a more aggressive practice with the same revenue might be worth. The negotiated settlement was not what Vivienne had anticipated when she had first sat across from Donna Peel 6 months earlier with a theory about a safe deposit box and a forensic accountant's inference, and the certainty that the gap between what she could see and what she believed must exist would resolve in her favor. The house sold and was split according to statute. The joint accounts were divided. The firm was valued, and the marital portion of its appreciation during the marriage was calculated and divided. The retirement accounts were handled through the appropriate legal instruments. It was equitable in the technical sense. Every item was assessed, every number was documented, and the result was specific and complete. It was not the $500,000 she had been certain was in that box. Elliott stayed in a corporate apartment for 3 months while the house was on the market. He did not mind the apartment. It was temporary, and he treated it as temporary, keeping only what he needed and not attempting to make it feel like something it was not. He had a coffee maker, his work bag, his clothes, and a box of books. He reviewed client files at the kitchen table in the evenings. He slept well because he had never had difficulty sleeping, even when things were difficult. He attributed this to the same quality that made him good at his work, which was the ability to put a problem down when you had done what you could do today, and there was nothing more to do until tomorrow. His brother took him to dinner on the Friday after the box. They went to the same restaurant they had been going to since their 20s, a neighborhood Italian place 2 miles from where they had grown up. The kind of place that changed nothing because nothing needed changing. His brother ordered what he always ordered and said very little about the actual situation, which was exactly right. And instead they talked about a structural problem his brother was having with a contractor on a commercial property he was developing. And Elliott listened and asked the questions that needed to be asked, and identified the issue in about 12 minutes, and explained it clearly. And his brother wrote something on a napkin and folded it and put it in his pocket and said, "You doing okay?" "Yeah," Elliott said. "I'm doing okay." His brother looked at him for a moment with the particular assessment of an older sibling who has known you long enough to know when you're telling the truth and when you're telling the version that's true enough to offer. He seemed to decide it was close enough. He picked up his wine. "Good," he said. His mother called him on a Thursday evening in December. She was 71 and lived 40 minutes away in the house where he and his brother had grown up. A Cape Cod on a corner lot that she had maintained with the particular competence of a woman who did not believe in waiting for someone else to fix a problem. She had been an accountant herself, decades ago, before she had Elliott and his brother, and decided that raising them was the more interesting project. He had inherited the precision from her, and the patience, and the specific habit of looking at structures, financial, physical, domestic, and finding the thing that was quietly failing before it became loud about it. She said, "How are you doing?" He said, "Better than I was. Better than I expected to be, actually." She said, "You know what your father used to say." "Tell me anyway," he said. He said the problem with building your life around what someone else needs you to be is that they get to decide when the project is done. She paused. "You never did that, Elliott. You built your own life, and you invited someone into it. That's different. That's something you still have. He sat with that for a moment. Outside the apartment window, the city was lit up and cold and in motion, the particular motion of a weeknight in December, people moving from one lit-up place to another with a purpose he could only guess at from this distance. "I know," he said. "I'm figuring that out." He found the house in February, a bungalow in a quiet neighborhood 20 minutes from the office. Not the same suburb, a different one. The kind of neighborhood where the houses were older and the lots were larger, and the trees had been there long enough to have opinions about the street. The house needed work. The porch was sagging on the south end. The kitchen was 30 years out of date. And there was carpet throughout the first floor that he knew, from the inspection, was covering original hardwood. He put in an offer the second day it was listed. He knew what it was without needing to think about it. It was a structure with good bones that had been neglected, and he was a man who understood how to bring something like that back. He moved in on a Saturday in March, with his brother, and a rented truck, and 2 pizzas, and a box of tools he had been carrying from apartment to apartment since before his marriage. They unloaded in 4 hours. His brother walked through every room and assessed each one with the specific eye of someone who had grown up doing this with their father. The eye that goes to corners, to ceilings, to the gap under a door, to the way a floor slopes or doesn't, to the sound a wall makes when you knock on it, and then turned and looked at Elliot and said, "The porch first." "The porch first," Elliot agreed. They ate the pizza on the kitchen floor because there was no furniture yet, sitting against the cabinets that were original to the house and needed repainting. His brother asked about the client situation, and Elliot told him it was steady. 3 new clients in January, one from a referral by a client who had been with him for 9 years. His brother nodded and ate his pizza. Outside, the March afternoon was cold, and the yard was bare, and the flagstone under the leaf mulch along the south fence was going to need releveling in places. Elliot had already assessed it. He had a list. He rebuilt it over 3 weekends in April. He replaced the rotting boards, reframed the sagging section, reset the posts in new concrete. He painted it the same gray as the house trim. He built 2 simple chairs for the far end, where the afternoon light came in best. Not elaborate, just solid, properly jointed. The kind of thing that would last. He put them out there and tested them, and they were level, and they were good. He planted tomatoes in a raised bed he built along the south fence in May, because his mother had always grown tomatoes, and because the season of a tomato plant is a satisfying thing. It follows a logic. It rewards attention. It produces something specific and real at the end of it. His daughter, from a relationship that had ended long before Vivienne, a daughter named Margot, who was 11 and lived with her mother and her mother's husband and came to Elliot every other weekend and on holidays, came to see the new house in June on a Saturday. She walked through every room with the serious inspection of a child who takes rooms seriously. She stood on the new porch and looked at the yard, and then looked at him. "Did you build these chairs?" she said. "I did," he said. She sat in one and considered it. "It doesn't wobble," she said. "It's not supposed to," he said. She accepted this as sufficient. They sat on the porch in the afternoon light, and he made her lunch, grilled cheese, the good kind, with sharp cheddar and sourdough, the kind she had asked for every time since she was 6, and she told him about school in the specific, dense narrative of an 11-year-old who trusts you with all the details, and he listened with the same quality of attention he brought to everything that mattered. He thought, sitting there on a porch he had rebuilt with his hands, in a house he was restoring piece by piece, watching his daughter eat a grilled cheese in the June afternoon light, about the index card he had left in the safe deposit box. "These are the contents of this box. There is nothing else." He had written it the day he opened the box 6 years ago, on the day he established the box for professional purposes, as a professional notation, an inventory, which was the accountant in him. The deep structural habit of documenting what a thing contains, so that no one, at any future point, can reasonably claim to be uncertain about what was and wasn't there. He wrote it because he wrote everything down. He wrote it because a record you create at the beginning, before any dispute exists, carries more weight than a record you create after, when motives can be attributed. He wrote it the same way he had always done everything, before it was necessary, because preparation is not paranoia. It is simply the practice of a man who understands that things go wrong and that the right documentation is the difference between a problem that costs you a month and one that costs you everything. He had not written it for this purpose. He had not sat in that bank 6 years ago with any particular foresight about the Tuesday in October when a sheriff's deputy would stand in that room. He had simply been, as he had always been, a man who documents what exists and does not claim what doesn't. And the result was that when the moment arrived where a theory about what he was hiding needed to be tested, the test was simple and complete and left no room for interpretation. There is nothing else. He had meant it as an inventory. It turned out it was also a statement of character and the most legally significant document in a case built on the presumption that he was something other than what he was. He thought about what Vivienne had believed was in that box. He thought about it without anger, the way you think about the load-bearing assumption in a structural failure, not with emotion about the failure, but with professional interest in where the error entered the calculation. She had looked at his life from the outside and seen the gap between income and lifestyle, and concluded that the gap implied concealment. She had not considered the possibility that the gap existed because the lifestyle was simply not a priority. That the man who drove the same Volvo for 11 years and renovated his own kitchen on weekends and kept his professional papers in a gray metal box at the bank was not hiding anything, but was simply not performing anything either. She had built a picture, and she had lived inside the picture long enough that it had stopped being a theory and had become, to her, a fact. And the fact had been wrong, as assumptions not tested against reality tend to become wrong, and the box had been the test. And now she knew what he had known all along. He did not feel triumphant about this. He felt something quieter and more complicated, the feeling of a man who has been understood incorrectly for long enough that the correction no longer brings satisfaction, only a kind of tired clarity. He went inside to do the dishes. Margot followed him and asked if she could help, and he handed her a dish towel and she dried while he washed, the way he had done this with his own mother as a child, the specific domestic rhythm of two people who do not need to talk to be together. He was not healed, exactly. He did not think of it in those terms. He thought of it the way he thought of the house, as a structure with work still to be done, rooms still to be restored, things that would take time and attention, and the patient application of skill he already had. He had done hard repairs before. He knew how they went. You work from the foundation up. You do not rush the framing. You measure twice and cut once, and you build what will last rather than what looks finished. He dried his hands and hung the towel back on the handle of the oven. He went out to the porch and sat in one of the chairs he had built. The evening was coming in slowly the way June evenings do, the light going amber and long across the yard where the tomato plants were 2 feet tall and climbing their stakes. He did not check his phone. There were emails he could read, and he would read them tomorrow. There was a client file on his desk that needed attention, and it would get attention in the morning. There was work, and there would always be work, and the work was good, and he was good at it, and it would be there in the morning the way it had always been. He sat until the light changed. He did not look back at the house. The yard was in front of him, and the evening was coming, and the tomatoes were climbing their stakes, and he was exactly where he was, which was where he had built himself to be. He went inside when it got dark. He left the grief at the door, not because it was gone, but because there was nothing left tonight that required him to carry it standing up. He turned off the porch light. He went to bed. He was up at 5:30. He made coffee. He went to work. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.